Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On February 22nd, the court heard arguments in Ysleta del Sur Pueblo versus Texas, a case which concerns sovereign authority to regulate non-prohibited gaming activities. Joining today to discuss this case is Anthony Ferate of Counsel at Spencer Fane LLP.
Thank you for joining me today. My name is AJ Ferate with Spencer Fane LLP, the Oklahoma City office of Spencer Fane LLP. Today we're discussing Ysleta del Sur Pueblo versus Texas. The case was argued on February 22nd of this year. I highlighted this case recently on a seat at the sitting with host Adam Liptak of the New York Times. I'm not going to go heavily into the facts of the case. I think I've summarized those well on that podcast. So if you want to hear a little bit more detail on it, I encourage you to go there. But I will provide you a brief summary of the issues in this case before we get going. So under Section 107A of the Tribes of Texas Restoration Act, the Alabama Cucheta and the Ysleta del Sur Pueblo were restricted in any allowance of gaming unless the state of Texas made the form of gaming legal. Conversely, 107B disallows Texas regulation of gaming under the same act. So the way that at least the tribes would claim that it functions is if bingo is outlawed under the act, the tribes cannot have bingo on the reservation. But if in any way, shape, or form Texas allows bingo, then 107B would come in and say that Texas cannot regulate in any way how that operates. They used Cabazon Band versus Riverside as their case law on that. We'll get into that a little bit more in a minute. But that is the basis of the case. So again, at issue, to make this very clear, if the state of Texas allows bingo under certain circumstances, does that automatically trigger 107B, allowing tribes to offer tribal bingo gaming? Now, let me talk a little bit about tribal bingo gaming here. It's not necessarily the bingo halls that you might see at your church parish. It's not the type that you would see down at the VFW. This is a machine that looks very similar to any other slot machine that you might see in Las Vegas. It has technology in it, a digital card in it, that actually acts as a bingo machine, as a bingo functionary, if you will, rather than if it were a Class 3 gaming machine under the Indian Gaming Regulatory Act. There is a distinct difference in the law between a Class 2 and Class 3 machine, and bingo squarely falls under a Class 2 gaming machine, which means that under Indian Gaming Regulatory Act, it would be bingo. So let me also add to the dynamics of this case. Texas is considered a Section 280 state. Generally, that means that Texas has authorized civil and criminal jurisdiction on reservations. There's only a handful of these states around the country. California is another one. Nebraska is one. But Texas did not actually apply under Section 280 to become a Section 280 state. It became one by function under the Tribes of Texas Restoration Act. Let's get into the argument a little bit here. Mr. Brant Martin, author of the cert petition on behalf of the tribe, argued the case rather than Carter Phillips from Sidley. He was the author of the merits brief. I struggled through the cert petition that was filed on behalf of the tribes. I understood the issues. I understood what was going on, but the cert petition did not make those issues clear to me. Those issues were made very clear by Mr. Phillips under the merits brief. I expected to see Mr. Phillips arguing the case. That gave me a little bit of concern because of the clarity of the briefs, but Mr. Martin handled himself well. The court, however, gave him kind of a rough time. They did not greet him warmly. The bench challenged him throughout his argument, and as I read the briefs and argument, I think he handled it well, given the hot bench that he was presented with. This changed when Anthony Yang got up to argue as Solicitor General on behalf of the Department of Justice, on behalf of the United States. He was accepted by the court. His questions and answers and his comments were all very well accepted. And Lenora Pettit, arguing on behalf of the Solicitor General's office in the state of Texas, more than capably held her own in the argument. She made the issues difficult for the bench and did very well. She's a very capable litigator on this forum, and this was her first time arguing before the Supreme Court. You wouldn't have known it from listening to her presentation. As I mentioned a little bit ago, this case revolves around Cabazon Band versus Riverside. 1987 case was the highlight precedent of the argument, really focusing on whether that precedent colored the text of the statute when Congress enacted it. California law at the time in Cabazon Band said only charities can operate bingo, very similar to what we had here in Texas. Texas law allows for charities, nonprofits, to operate bingo in the state. Texas's arguments, A, are this is not bingo, and B, that the tribes are not a nonprofit. So then we turn to Justice Roberts. Justice Roberts wondered aloud, do these look like a slot machine? He wondered to Mr. Martin. Mr. Martin's response, which was found humorous by everybody in the courtroom, Mr. Martin said, it looks like an electronic bingo machine to me. And really he explained that by saying that there's an electronic card random number generator that makes machines compete against other machines to classify it under Class 2 gaming, as I discussed previously. Justice Alito said they're either bingo or there's something else, and we'll generically call it dingo. That, again, received many laughs in the courtroom and was a humorous moment. Justice Alito continued to ask, are there experts that can be qualified on what is bingo? To which Justice Breyer immediately replied, you can ask my grandmother. It was quite a humorous moment in the argument and was enjoyed throughout the room. Justice Gorsuch turned the argument a little bit on, does Cabazon need to be overruled? I think it was a little bit of a rhetorical question. Mr. Yang received that question first, and he said that it's a longstanding precedent and is not at issue in the case, even mentioning that Cabazon is embedded in the Indian Gaming Regulatory Act, which was passed on the same day as the Tribes of Texas Restoration Act. Justice Gorsuch continued to press this question, does Cabazon need to be overruled? I believe it was a rhetorical question, really because the Cabazon definition is very different from how regulation, how prohibition are discussed and debated outside of the Cabazon ban precedent. But there was not a single person, a single litigator in the case that was willing to say that Cabazon should be overruled. Justice Breyer asked the question, how would we determine if this is bingo? And Mr. Yang, on behalf of the Solicitor's Office, said this is usually answered in the Indian Gaming Regulatory Act context, and there are three primary characteristics of bingo under that act. First, a card bearing numbers or designators has to exist. You cover those numbers when they are identified, and you win by covering an arrangement of numbers. That can be accomplished digitally and is arguably done so here. Of course, that'll be handled when it gets back to the district court level. Justice Alito and Justice Kagan took the argument a little bit different, took it on a tangent of their own, really focused originally on Indian canon. Is there a reason that we give deference to the tribal interpretation under the Indian canon? Regulations, statutes affecting tribes, treaties are all given a deference in a vague instance. If there can be different viewpoints, the court is to give deference to the tribal perspective on that. That doesn't mean that they win. It means that they get deference on the issue. Justice Kagan took that a little bit of a step further and talked about substantive canons, suggesting maybe we should toss them all out, and said, I think we should. Justice Kavanaugh jumped in on this conversation as well, asking a few questions along these lines. And interesting conversation that I will leave for another Federalist Society podcast, but worth contemplating. Justice Breyer commented to Ms. Pettit on behalf of the state of Texas in his own way. He kind of addressed textualism from his own perspective. He said there used to be ways that we used to look beyond the text, and we used to look into this. We would read committee reports. We would read testimony before committees. We would read what others said on the floor. This at times shed some light on the proper answer, Justice Breyer suggested. Said it was an odd single path, but was, I think, one that he was hearkening back to prior to the expanded view of textualism as we approach it. Many of the justices approach it in today's Supreme Court. Justice Kagan highlighted that without context here, if we weren't looking just at if we weren't using cabazon ban, if we didn't look at the Indian Gaming Regulatory Act, which it was, again, passed on the same exact day as the Tribes of Texas Restoration Act, if we didn't have all of that context, this would be an easy win for Texas. But we do here, she pointed out, saying the argument of the cabazon regulatory view here is strong, and it's written all over the statute. If I were a wagering man, since we're talking about Class 2 bingo rather than Class 3 gaming, I will say I'm not. But if I were a wagering man, I believe that I heard possibly 4 or 5 additional votes beyond Justice Kagan to side with the tribes. I'm not wedded to that. That's just a crude estimate, just based on listening to the argument a couple of times. I thank you for listening with me today. I believe we'll be back once the case is decided by the court. Again, for today, my name is AJ Ferate with Spencer Fane LLP. Thank you for your time.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.